Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, who is this defendant? Hooper. All right, we're on page 14's probation violation. State ready? You may call your first witness. Right, if you'll step around, raise your right hand, be placed under oath.
Will you state your name for the record, please?
Christina Bright.
And are you an officer with Tennessee Board of Probation and Parole?
I am.
Did you have Ronnie Hooper Jr. on your, as one of your probationers?
Yes.
Okay. And did he at one point in time have a different probation officer?
He did.
Okay, and who was that?
Officer Harbor.
Okay. And on August 25th of 2025, did you request a violation of probation on Mr. Hooper?
I did.
And can you tell us the basis of the violation?
The basis is that I had received basically absconding. I had received information that he was evicted from the residence that I had on file for him 5 or 6 months prior. The phone number that I had for him, I was not getting any responses from, so I was not aware of where he was.
Okay. Did he report to your office at all?
Eventually, after I did the warrant.
Okay. And on here it says, okay. Was Mr. Hooper supposed to report per conditions of probation?
Yes.
Okay. And you stated he had absconded, is that correct?
Yes.
When
at
was
that time.
When was the last time he had reported?
I want to say, I believe in April.
Okay. Of 2025?
I believe so.
And this date that you requested it was in August, so.
Correct.
Several months later.
Correct.
Do you know what efforts were made, if any, from the transfer from Officer Harbor to you in reaching Mr. Hooper?
I had reached out several times by phone or text and did not receive any responses. And then I was contacted by Scott Tummins requesting a new address for the offender if we had a different address. And I told him that all we had was that one. Okay. He informed me that I believe he's the landlord, that he was the one that had evicted him 5 or 6 months prior.
Okay.
And that was at the end of July.
So you received no contact from him, and when you attempted to contact him, nothing, obviously the phone numbers, you got no response.
Correct.
Okay. And he didn't update his phone number or his address with probation?
Correct.
Is this the first time Mr. Hooper has been violated?
I believe this is his third time.
Okay. So if I was to say March of 28th of 2023 and November 19th of 2024 as being two prior violations that are in the record, does that sound correct to you?
Correct.
Thank you. I don't have any further questions.
Mr. Howard?
Inherited this case when Mr. Harbor left your office, is that correct?
Yes.
And when exactly was that?
I want to say July
In
1st
July of this
is
year?
when I would receive the case.
Okay. And at that time, were there any notes in the file that you received that Mr. Hooper wasn't in compliance?
No. Not at that time.
According to Mr. Harbor, he was in his good graces.
Yes, address, all of that, but there was nothing in there stating that any address or phone number changes.
And how many times would you say you tried to reach out to him?
I can't recall off the top of my head
Couldn't
how many
estimate?
times. No,
Okay. And when did you finally make contact with Mr. Hooper?
it was after the warrant was completed.
Did he have any idea that a warrant had been taken out?
I could not tell you on that.
You hadn't told him?
No.
Is that- All right, and then he came to your office of his own volition, is that correct?
I had received a text message from him from a different phone number asking what he needed to do. And I told him he could report to the office on this date and asked him for a good time for him, and I got no response.
Okay, and so when was it that he reached out to you to make contact with you?
I believe it was September 4th, I believe.
Nothing further, Your Honor.
General?
So from July 1st to September 4th, there had been no contact with Mr. Hooper, is that correct?
Correct.
And upon reaching out to the numbers and address that he provided to probation, you were still not able to reach him, is that correct?
Correct.
No further questions.
Anything further, Mr. Howard? Thank you, officer. You may step down. State may call your next witness. State has rested. You may call any proof you wish to put on your proof. If you'll step around here, I'm going to ask you to let the clerk place you under oath.
So, Mr. Hooper, you heard Ms. Bright testify just then. When was the first time you met Ms. Bright?
It was Wednesday, September the 9th or 10th.
Okay, and you've been on probation for a little while. Mr. Harbor was your probation officer?
Correct.
What was your relationship like with Mr. Harbor, and how did you usually get in contact with him?
It was text messages. If he needed something, he would text me.
How regularly did you go in to see him in person?
Whenever he asked me to, I would always show up.
All right, when was the last time you recall Mr. Harbor contacting you?
He got word to me I needed to, that he had quit and I needed to report.
About when was that, do you recall?
It was around the beginning of September. I called the office, talked to Mr. Fry. He took my number. I guess, was it Labor Day? I called back, got Miss Bright's number.
We've heard a lot about addresses and phone numbers. Did your phone number change at all during that time?
It had,
When did it change?
March or April or somewhere there, maybe.
And did you ever receive any text from Ms. Bright?
Oh.
Did you have any idea that anyone other than Mr.
Well,
Harbor?
yes, after I contacted her, sent her one, she
Prior
responded.
to September of this
No.
year, between the period of April and August, I'll rephrase the question.
Oh, sir.
And did you have any idea that Mr. Harbor wasn't your probation officer during April to August?
Oh, sir.
So where were you living during this time? Just walk me through your living situation during that time period.
I was evicted from 518 Smith Street, and I started living at 106 Dogwood Court.
Right. And was that where you were still living at the time you made contact with Ms. Bright, or had you went to a different place?
Still there.
Okay. You've just mentioned two addresses. Where are, this is a silly question. Are those located here in Dickson County?
Correct.
Right.
City.
At any point, did you leave Dickson County?
Oh,
Were you making any active effort to avoid apprehension or contact with probation?
oh, sir.
I'll pass the witness.
General, you may ask.
Mr. Hooper, what address did you say you were living at?
106 Dogwood Court.
So you never lived at 518 Smith Street, Charlotte, Tennessee?
Yes,
Okay. And you were evicted from that property?
correct.
Okay. But you never gave your probation officer that new information, did you?
Yes, I did. He showed up there,
Okay, so you gave it to who?
Mr. Harbor.
Okay. And you changed your phone number in March or April, is that correct?
But,
And did you update that information?
well, I didn't have to because I still had the phone, still had the number, still have it now.
You said you changed your phone number in March or April.
I have another number, but I still have that one.
Okay, so you're saying that Officer Bright never contacted you on the number that you provided to probation? Okay. And this is not your first time that you violated probation, is it?
No,
In fact, you violated 2 separate times within, I guess, a year, 2023 and 2024.
no, it was thrown out, so it wasn't a violation.
So you're saying you never did admit to violations in 2024 and 2023?
I was 23, but 24, no.
Your Honor, may I approach the
You may.
witness?
All I can say is that the case in that city was thrown out.
Redirect, Mr. Howard.
Oh, the document that General Wojnarowski just presented to you, correct?
Correct.
Do you recall in November of 2024 admitting to a violation of probation?
I do not.
Your memory the greatest? Is it possible that maybe you forgot about that?
Could be.
Nothing further, Your Honor.
So let me ask this question. When you were on probation, and according to the proof, it's been several months since you had last reported to the probation office. Was that normal, that you just didn't report on any regular basis?
Mr. Harbor said if he needed me, he would text me, and when he did, I've done what he wanted done.
But as far as having you report on a regular basis, you're saying that you just waited for him to call you? Okay. Thank you. You can step down. Anything further, Mr. Howard? Anything further from you? Either side wish to be heard in argument? Let me just save you the trouble. There's a little bit of confusion on my part about exactly how he was supposed to be reporting. He says he was just, of course, we don't have his original probation officer there. I have some concerns about his proof. I find that he is guilty of violating his probation. I'm going to order that he serve 60 days in addition to what he's already served, and then I'm extending his probation for an additional 1 year. I'm going to give him a chance to determine whether or not he's actually going to comply or not. Next time, there will be no excuses, and this will be, Ms. Bright, if you are his probation officer, he will have to report regularly in person. It will not be him waiting for you to call him. So his first missed opportunity for us to report after he serves his 60 days will be a violation. It will be a no tolerance, zero tolerance violation if he misses one. That is the judgment of the court. All right, we're ready on Marcus Pace. All right, I've been handed a document indicating that Mr. Pace is going to be entering a plea in docket number 2023 CR 21 and CCR or CR 36.
Yes, sir.
He's going to be entering in case number 2023 CR 21, count 1. He would receive a sentence of 15 years to serve in the Department of Corrections. Counts 1 and 2, count 2 would be, I'm not sure I can read this. You want to explain to me what
Yes,
this is?
Your Honor, I can do that. I
can't read your-
apologize. We usually type these up, but this was done at the last minute. Judge, he's going to plead to counts 1 and 2 of case number 2023 CR-21, 15 years to serve in the TDOC as a range 1 offender, concurrent to each other and concurrent to any Davidson County cases. $5,000 fine and cost, forfeit any item seized to the relevant agencies involved. Count 3 of case number CR-21 and count 1 of case number CR-36 are nollied and dismissed in settlement.
All right. Mr. Pace, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Marcus Pace.
Mr. Pace, you're here today charged with several different indictment numbers and different crimes, but have you seen or been shown a copy of the charges that you're pleading to and gone over with Mr. Lockhart the range of punishment you're facing, as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to these 2 counts, and the remaining charges would all be dismissed. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
Do you understand at trial you would have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine all witnesses the state called, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
You understand that's going to result in 2 convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial and to an appeal by entering this plea?
Yes, sir.
I need him to sign off on this plea form, please. All right. Do you understand everything I've explained to you?
Yes, sir.
And do you still wish to enter this plea of guilty according to this agreement?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand if you plead guilty, the court of the state could ask you questions about the offense, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if you were to be found to be lying under oath.
So,
In other words, you're testifying under oath today, and you're entering a guilty plea.
Oh,
If the
yeah.
state wants to ask you questions about it, or I'm going to ask you questions about whether or not you're guilty of that, but your answers are sworn testimony, so if you were lying under oath, that sworn testimony could be used as evidence in a prosecution for perjury. In other words, as long as you tell the truth, you don't have a problem, but if you're lying under oath, that creates problems.
Yes,
Is that
sir.
understood? All right. You understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty.
yes, sir.
Then I will ask you this question. Are you in fact guilty of these charges, which are, I think they are drug-related charges, is that correct?
Yes, sir.
State want to give me a factual basis for it? Step aside, you can do it there if you'll turn your microphone.
Judge, this is, Marcus Pace is part of the 27 defendant conspiracy
I see,
case.
okay.
Mr. Pace was involved as what was determined to be a runner in the case. He was located during a search warrant of a house that took place after a wire had been placed on Dantes Goods' phone. The search warrants took place, and over 17 and a half pounds of methamphetamine was located in the home that numerous people were in, including Mr. Pace. They also located a large number of firearms. Mr. Pace, multiple people have provided statements and are willing to testify that Mr. Pace was delivering both fentanyl as well as methamphetamine to them, and they were bringing those drugs back to Dickson County to sell.
Right. Mr. Pace, are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Lockhart's done a good job of representing you competently?
Yes, sir.
Mr. Lockhart, do you know of any reason you should not enter this plea?
No, Your Honor.
Anything further from the state? In Marcus Pace, in docket number 2023 CR 21, I find you guilty, sentence you to 15 years in the Tennessee Department of Corrections. This is count one. 15 years in Tennessee Department of Corrections to serve, and that will be, and count two, you're also found guilty, sentenced to 15 years. Those two are served concurrently with one another and concurrent with any Davidson County sentences that you may have. You're ordered to pay a $5,000 fine and cost. All items seized are forfeited to the agencies involved. The remaining charges that you had are all dismissed, and you're getting pre-sentence jail credits from January 24th, 2023 until today, until July 18th of 2023. But he has pre-sentence jail credits for anything else. You just need to make sure he gets them. All right, thank you.
Thank you, Judge.
5,000 on each count.
Page
Can you bring
16.
up, is this Mr. Lee?
Judge, I just met Mr. Lee. As it turned out, when I received the information from the state, there was an issue with one of the witnesses.
You have a conflict with one of the witnesses?
Yes, Your Honor.
Right.
I've prepared an order asking to be released.
Lawyers, Mr. Lee, you have the right to have a lawyer who is free from any sort of conflict that would restrict them in being able to adequately represent you. And Mr. Vandervoort has indicated that when he got the information and saw witnesses, one of the witnesses would create a problem for him. You want somebody who's free to go after any witnesses that might be testifying against you rather than, having a conflict. So I'm going to allow him to withdraw. This is the most current list, is that correct?
And Judge, Mr. Lee has currently had, or has previously had on this case, or the co-defendant. The attorneys disqualified from this case so far are Lee Spratt, Mark Odell, Sidney Franklin, Crystal Wilkerson, and
Slow down. Lee Spratt.
Lee Spratt, Mark Odell,
Okay,
Sidney Franklin,
okay.
Crystal Wilkerson, and then I believe he had previously been appointed Vid Sankar.
All right. I am allowing Mr. Lockhart to withdraw, and Mr. Yeager, who was here earlier on a case, will be appointed to represent you.
Just for the record, Mr. Vandervoort to withdraw.
That's what I say.
You said liar.
I'll get you too confused on it. All right,
Well, he's much younger and probably.
I understand. I'm going to allow Mr. Vandervoort to withdraw because of his conflict, and we'll appoint Mr. Yeager, what's his first name? Bo Yeager? Bo Yeager was here arguing a motion earlier, and since he has taken a retained case, I will appoint him to represent Mr. Lee, since we have a number of conflicts for the local bars. All right.
Thank you, Your Honor.
He'll be notified. Is this case set for status? And that's in front of Judge Turner Wallace. All right. Your new lawyer will be notified. He'll hopefully be in touch with you as quickly as possible. And then question of whether or not it's going to go forward with the trial date will have to be up to your lawyer and to the state. And the judge will have to determine whether or not you need additional time. So, all right, thank you. All right, we're going to stand in recess for lunch until 1:15. Let me make this announcement to council. If we are unable, whatever we're not able to get to today, and I'm assuming we're not going to be able to get to everything, reasonable period, will be rolled to Wednesday, this coming Wednesday, October the 1st, and possibly as early as 11, but we'll know that by the end of the day, either 11 or 1 o'clock on the first day of October.
All rise. Court will be in recess till 1:15.
Do you know where his car tag is? I had it hanging. Yeah. No, I think it's hanging up. Yes. Same recess. Yeah. They need to recess in. They don't even have recess. I'll tell you that. They don't have PE, they don't have recess. No wonder they're fat, crap, crazy. I think this is the only thing he needs.
Timothy Gish, page 11. All right, have a seat at the table. State ready? All right. You may call your first witness. I'm sorry.
May I approach, Your Honor?
You may. All right, I've been handed a document indicating that Mr. Gish is going to admit his violation of probation, be revoked to serve with credit for all of his time. All right, Mr. Gish, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Mr. Charles Gish.
Mr. Gish, you are here today charged with the violation of probation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed as we've done with the public defender? Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal? You can speak up just a little bit because we're recording everything, okay? Do you understand that if you enter this plea of guilty, you're waiving your right to a hearing and to an appeal. All I'm going to do is revoke you to serve the rest of your sentence with credit for all your time.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a hearing and go ahead and enter a plea of guilty to this charge?
Yes, sir.
Let me have you sign off on this form, if you will, please. All right. Then upon your plea of guilty to the charge of violation of probation, I find you guilty, order that you be revoked to serve the balance of your sentence with credit for all your time, and your time credits are set forth on this document. Okay? Thank you. Brett, we have a trial date of November the 6th and 7th, according to my docket.
That's correct, Your Honor. And today was a motion date for Mr. Godwin. If the court will note in the file, General Bryson filed a notice of intent to which I filed a response. That's not right for a motion hearing. It could potentially end up in a lengthy jury out, which is the reason I filed a response to her notice. So I don't think that's right for a hearing. That depends on how things go during the trial. So other than that, there are no suppressions or any other motions like that to take up. I mean, my understanding is we're proceeding on 2021 CR 256.
Yes. The one out of White Bluff, the one that occurred last in time.
Yes. So
I'm sorry, what was that?
we were just syncing up as to making sure which case is set. It's 2021 CR 256.
Well, this motion was originally set to be heard on the 14th day of May of this year.
A motion.
Second motion, defendant's motion, second motion to bar the state from seeking enhanced punishment or any alternative to continue the trial was heard on May the 16th of 2025. I granted the state's notice, and I ruled that I granted your motion to continue the trial, and the trial was reset for the 6th and 7th of November. And then any additional motions were set for today. So I've already heard your motion to bar the state from seeking enhanced punishment or an alternative to continue the trial.
Yes, that's more or less, that's what I'm saying, is that I don't have any motions today, but there are other cases. So I'm kind of taking these one by one, if that's how we're
The
going to
case
go.
that's set for trial is at 256, correct? General?
Yes, that's the one that's on the docket, 2021 CR 256. I just want to make sure that I'm not, if the other cases need motions, we may have to do that, or I'd ask to do that separately. This is.
I will give you certainly an opportunity to hear your other motions, but the main thing is that are all motions relating to the case set for trial in November, have they all been heard and disposed of?
They have.
Yes, Judge. The state has filed a notice of potentially introducing 404B evidence. However, it is a conditional motion to where if the defense introduces the issue of consent, then the state would go forward asking the court an appropriate means. That's what he's saying. We potentially have a long jury out in the middle of the trial. but there's no way to take it at pretrial.
Well,
because that-
obviously, yes. I mean, in this case, the defendant is charged with rape without consent and also with aggravated burglary. And under the circumstances, if you're talking about 404B evidence that's only admissible if the defense raises it, is that what I'm understanding?
Yes, Judge, I don't think it would be admissible under any other grounds unless
Then
consent.
there's no way to avoid that having to be heard during the trial, so we'll take it up. We have it set for the 6th and 7th of November. We will leave it set on that day. And any other motions that need to be heard are going to have to be filed ASAP, but I don't anticipate that that's going to be the case. So. All right, case is set for trial. We'll leave it set.
Thank you, Your Honor.